Hello friends, as part of my video lecture series, today I would like to explain the concept of law of gifts as under Transfer of Property Act 1882. According to section 122 of Transfer of Property Act 1882, a gift is the transfer of certain existing movable or immovable property made voluntarily and without consideration by one party to another and accepted by or on behalf of the latter. Gift is purely transfer of certain existing property. The property may be movable or immovable. Such property should voluntarily transfer by one party to another party without any consideration, but the another party should accept the gift. The person making the gift is called donor, and the person to whom the gift is made is called donee. On the basis of this definition, we can easily identify certain essentials of a gift. Coming to the essentials of the gift, there must be two parties, the donor and donee. The person who makes a gift is known as the donor, to whom such gift is made is known as donee. Both the donor and donee must alive at the time of making a gift, hence it is known as transfer in between inter vivos. The next essential element is transfer of ownership. There must be transfer of all the rights over the ownership. Here, the ownership over certain movable or immovable property should be transferred from the donor to donee. From the donor to donee, that is the meaning of transfer of ownership. Here, while making the gift, it is permissible to make conditions. The conditions may be precedent. If any condition is made contrary to the Act 1986, the Act 1882, are not permissible. The next, existence of property. Existence of property. There must be certain existence of property in order to transfer from donor to donee. The property may be movable or immovable. It may be movable or immovable. It must be in existence at the time of transfer. It must be existence at the time of transfer. Must be transferable property within the meaning of section 6. It must be transferable property. Future property cannot be gifted according to section 122 of the Act 1882. The next essential element is no consideration. Here, a gift is an exception to consideration. Gift is generally transferred by the donor to the donee on the love and natural affection, or the donor may expect the spiritual or moral benefit. The fifth essential condition is voluntarily. The transfer of certain property, certain existing property, should be voluntarily done by the donor. Here, the word voluntarily denotes that gift must be made voluntarily with the free consent. The word free consent denotes the same meaning under Indian Contract Act. The concept of free consent is explained in Indian Contract Act. The same meaning is used in the word voluntarily. Gift must be made voluntarily, without coercion, without undue influence, without fraud, etc. The next sixth essential element is competency of donor. Donor must be competent to contract. He must be a major. He should not be a minor. He should have sound mind. He should not be a disqualified person by the law. He must have title to property or authority to transfer the property if it is not his own. He must have the title to the property. If he is the true and absolute owner, then he can transfer such property in the form of a gift. Or if he is the person in authority, he can also transfer such property as gift to the donee. If he is not an absolute owner, if he is not the person in authority, then he cannot transfer such property as gift to the donee. He becomes incompetent. The next essential element is acceptance by donee. Acceptance by donee. The donee must accept the gift given by the donor. The acceptance of gift should take place during the lifetime of the donee. During the lifetime of the donee. Gift should be accepted by the donee or someone on his behalf. Here the donee may accept the gift or on his behalf his guardian or any person who is authorized on his behalf can accept such gift. A gift may be made to a minor. Here the donee may be a minor, but the donor should not be a minor. A gift cannot be made to public at large. The gift should be made by the donor to a specific donee. Here, the principle, the acceptance of gift should take place during the lifetime of the donee. If the donee dies before accepting the gift, then such gift becomes void. The next important provision is mode of making a gift. It is explained under section 123 of Transfer of Property Act 1882. A gift of immovable property, here it is a gift of, not a, it is a gift of immovable property must be made through registered instrument signed by 2 witnesses. A gift of movable property, in case of a gift of movable property, registration is optional, but delivery of possession is important. If the gift is an immovable property, then it must be made through a registered instrument. Registration is compulsory, and attestation by 2 witnesses is also essential. Such delivery may be made in the same way as goods sold may be delivered. Here, as the goods sold may be delivered in the same procedure, the gift may be delivered from the donor to donee. Here, effect of registration of gift. Effect of registration of gift is explained under 123 of Transfer of Property Act. 123 of Transfer of Property Act. If the gift has been accepted, but the donor dies before the deed is registered, here the gift has been accepted by the donee, but the donor dies before the deed is registered, the transfer may be completed even after the death of the donor. Here the principle is the donee must accept the gift during his lifetime. Here the donee accepted the gift during the lifetime. Here the donor dies before the gift deed is registered. Then the transfer may be completed even after the death of the donor. Even after the death of the donor, the donee may get the deed registered. This table is most useful in order to understand the effect of registration of a gift. Here it comprises of two columns. Column 1 is about type of property. In column 2, the necessity of registration is listed. In case of mobile property, the registration is optional, but delivery of possession is important. If the property is immobile property worth below 100 rupees, then the registration is optional. If the property is immobile property and worth of such immobile property is 100 rupees and upwards, then the registration is compulsory. The donor should affix his signature in the registration deed of the gift. Two witnesses must affix their signatures in the gift deed at the time of registration. In Venkatramana Reddy versus Pallati Ramareddy, it was held that gift becomes effective after execution of the document. It can be registered subsequently even after the death of the donee. Here, even after the death of the donee, the registration may take place. In Kalyana Sundaram Pillai versus Kuruppa Mupanar, it was held that after acceptance deed of gift and before registration, the donor could not revoke the gift. After acceptance deed of gift and before registration, the donor could not revoke the gift. It is one of the landmark judgments given by the apex courts. Coming to the next concept, kinds of gift. The Transfer of Property Act 1882 categorized various gifts under these four heads. The first head or the first category is void gifts. These are explained under section 6, section 122 and section 124, 125, 126 and 127 of Transfer of Property Act 1882. The second category is onerous gift. It is explained under section 127. The third category or third head is universal donee. It is explained under section 128 of Transfer of Property Act 1882. And the fourth category is donatio mortis causa or deathbed gift. It is explained under section 129 of Transfer of Property Act. Section 129 of Transfer of Property Act speaks about donatio mortis causa or deathbed gift. Coming to the first category, void gifts. The concept of void gifts is explained under section 6, section 122 and section 124 to 127 of Transfer of Property Act 1882. The following gifts are declared void according to Transfer of Property Act. The first one is gift made for unlawful purpose. Gift made for unlawful purpose is declared as void gift under section 6. Under section 6H of Transfer of Property Act, if any gift made for unlawful purposes in order to meet the unlawful objects shall be a void gift. Here, a gift made by Mr. A to Miss B for previous illicit relationship between them. It is a gift made for unlawful purpose. Hence, it is treated as a void gift. A gift subject to condition and the fulfillment of which is impossible. If there is impossibility of performance, if it is impossible to meet the condition fixed, then under such conditions, under such circumstances, such gift is treated as void. Next, if donee dies before acceptance, here section 122 speaks about this. Section 122 of Transfer of Property Acts speaks about void gift in case of donee dies before acceptance. If the donee dies before the acceptance, then it becomes void. The donee should accept the gift from the donor within his lifetime. The gift by a person incompetent to contract is treated as void gift according to section 7 of Transfer of Property Act. For example, the person incompetent to contract or well explained in the Indian Contract Act 1872 under section 11. Section 11 of Indian Contract Act 1872 explains the competency of the parties or capacity of the parties to enter into a contract. A minor, a lunatic, the person disqualified by the law or by the court, or incompetent to enter into a contract. The insolvent is incompetent, alien enemy is incompetent, a person who does not completed the age of 18 years is incompetent, a lunatic is incompetent, an idiot is incompetent to enter into a contract. In the same way, in the same sense, a minor, a lunatic, the person disqualified by the court, alien enemies and insolvents are incompetent to gift. The second category is onerous gifts. It is explained under section 127 of Transfer of Property Act. The concept of onerous gift is explained in two paragraphs. Here I have distinguished these two parts. Section 127, that is related to onerous gift, is explained under two parts. Here part 1 is related to single transfer of a gift. Part 2 speaks about separate transfer of the gifts, separate transfers. Here several things are transferred by the donee to the same donor in a single transfer. Under such conditions, several things, several properties are gifted by donor to the donee in a single transfer. Several gifts are transferred by donor to the donee in a single transfer. Under such conditions, the donee either accept the whole transfer or reject of whole transfer. Here the entire thing, several gifts or several things, the several things are gifted to donee, the same person, in a single transfer. Under such conditions, the donee either accept the whole transfer or reject the whole transfer. He has only two options. He may accept the whole transfer or he may reject the whole transfer. Why? Because the several things are transferred in a single transfer to the same person, to the same donee. Here, in several things, in the same gift. One thing burdened by obligation, others no burdened. Under such condition, if a donee accepts the unburdened thing and if he wants to reject the burdened thing, then it becomes void. He must accept either whole gift or he must reject the whole gift, the whole transfer. It is part 1 of onerous gift, which is explained under section 127. Coming to the second part, if several things are transferred to the same donee by the donor in separate transfers, under such circumstances, the donee has the liberty to reject one or accept others. He may reject a few things from the several things. He may accept the other things. Here the gift of several things is transferred by the donor to the donee in separate transfers. Under separate transfers, if several things are transferred by the donor to the donee, to the same person, donee is the same person, the donee has the liberty to accept a few things. He may reject few other things. He has the liberty. He has the right to, he has the liberty to accept few things which are beneficial to him. He may reject which are burdensome to him. He may accept the things beneficial to him. He may reject the things which are burdened by obligation. One thing burdened by obligation, others are not burdened. One thing burdened by obligation, others are not burdened. Here one thing is burdened by obligation, others are not burdened. Here one thing is burdened by obligation, others are not burdened. The first 2 points are same. But the burdened thing and unburdened things, these are the several things. These several things are transferred by the donor to the donee in a single transfer. But one thing burdened by obligation, others not burdened, all are the several things. These several things are gifted by the donor to the donee, the same person, in separate transfers. He may accept one transfer. He may reject the another transfer. He may accept one thing in one transfer. He may reject the other thing in another transfer. It is part 2. Here it is part 1. It is one of the most important provisions under gift, which is explained in Transfer of Property Act 1882. Here, the onerous gift to incompetent person, we need to understand this concept. The onerous gift may be transferred by the donor to the donee, even the donee is incompetent person. If the gift is burdened by obligation, if it is burdened by obligation, it should not be transferred to incompetent persons. If any gift is not burdened, it is beneficial to incompetent person, then such gifts may be transferred to incompetent person as onerous gift. It's the most important principle with regard to incompetent persons. Next, the third category is universal donee. It is explained under section 128 of Transfer of Property Act 1882. A universal donee is one to whom all the properties of donor have been given and is liable for all debts and liabilities. Here, universal donee is one to whom all the properties of donor have been given. All the properties, here all the gains are given by the donor to the donee along with all the pains. Here the donee is given all the properties, here these are the gains, all the debts and liabilities, these are the pains. All the gains as well as all the pains are given by the donor to the donee at the time of gift. Such donee is called universal donee. The object of this concept is to protect the interests of the creditors of the donor. To protect the interests of the creditors of the donor, the universal donee is the one to whom all the properties of the donor have been given and he is liable to all the debts and liabilities of the donor at the time of the gift. Hence, in order to protect the interest of the creditors, here the universal donee receives all the gains. At the same time, he has an obligation to pay all the debts to the creditors of the donor. It is also an obligation. It is the other side of the coin. In one side of the coin, he gets all the properties. On the other side of the coin, he has an obligation to pay the debts to the creditors of the donors. In order to construe the concept of universal donee under section 128, there must be a gift consisting of donor's whole property. The donee is personally liable for all debts due at the time of gift deed. The whole property and all the debts, all the liabilities should be transferred by the donor to the donee at the time of gift deed. Here the donee is known as universal donee. The universal donee is liable to pay the debts to the creditors of the donors. He conferred with certain privileges to enjoy the properties of the donors. In Anuradha versus Lakshmi, in this case, it was held that the property comprises of must be both mobile and immobile property. Here all the property includes both the mobile and immobile property. Both the mobile and immobile property. The property comprises of both the mobile and immobile property. If it is only immobile, he does not universal donee. If only immobile property is transferred, if only all the immobile property is transferred by the donor to the donee, then such donee is not treated as universal donee. The donor must transfer both the movable property and immovable property to the donee as a whole. Under such conditions, the donee must take the liability to pay the debts to the creditors of the donor. He has certain privileges to enjoy all the properties, including the movable and immovable. It is held in Anuradha versus Lakshmi. In this case, it is held that the property comprises of must be both movable and immovable. If it is only immovable, then such donee is not treated as a universal donee. The next concept is the next kind of gifts. The next kinds of gift is donatio mortis causa. Donatio mortis causa. It is also known as deathbed gift. Section 129 of the Act 1882 explains donatio mortis causa. When a gift is made by a donor when he was in critical condition, likely to cause his death, it is called donatio mortis causa. The gift is made by the donor. The donor's condition must be critical. The condition likely to cause his death. If under such condition, if such donor transfers his property without consideration voluntarily to the donee, such gift is known as deathbed gift or donatio mortis causa. It means donation made out of death, and hence it is known as deathbed gift. The Transfer of Property Act 1882 deals with this concept in respect of immovable property only. The deathbed gift is purely related to immovable property, not related to movable property. It is not related to gifts of Mohammedan law. It is an exception. It is an exception. Section 191 of Indian Succession Act deals with this concept with regard to movable property. Section 191 of Indian Succession Act deals with the transfer of movable property at the time of critical condition likely to cause the death of the donor. Section 129 of Transfer of Property Act deals with the transfer of immovable property only. Transfer of immovable property only at the time of critical condition likely to cause the death of the donor. The deathbed gift is valid only when the donor dies. If the donor survives without the death, then it becomes void. It has no effect before the death of the donor. Once the result is the death of the donor, then it becomes an effective one. It becomes an effective one. The gift becomes effective. Before the death of the donor, it has no effect. It has no effect. It is not valid. It becomes valid only when the donor dies. Coming to the features of donatio mortis causa, the deathbed gift, which is explained under section 129 of Transfer of Property Act 1882. Here it does not related to movable property. It is purely related to immovable property. It is not related to movable property. There must be some contemplation of death or likely to cause death. The donor must suffering from illness. There must be some immediate apprehension of the death. The possession delivered to the donee in his deathbed or from his deathbed. Gift void if the donee recovers, if the donee survives. Here, section 129 shall not be deemed to affect any rule of Muhammadan law. It is an exception. Muhammadan law, the gift of Muhammadan law, the concept of gift of Muhammadan law is not affected by section 129 of Transfer of Property Act. Gift of Muhammadan law and the deathbed gift in case of movable property is also one of the exception. Movable property is one of the exception for donatio mortis causa or deathbed gift. The next one is revocation and suspension of gift, which is explained under section 126 of Transfer of Property Act 1882. The general rule is gift once completed cannot be suspended or revoked. Once the gift is completed, then it cannot be suspended or revoked by the donor. Here this concept is very similar to what an acceptance to an offer under Indian Contract Act 1872. But there are two exceptions for this rule. The two exceptions are rescission and agreement. The revocation or suspension is possible under the following two circumstances. One is by rescission. By rescission, the gift may be revoked or suspended. If the gift is made by employing coercion, fraud, undue influence, etc., these concepts are explained under Indian Contract Act 1872. Under Indian Contract Act 1872, there must be free consent. If the consent is obtained by the donee from the donor at the time of transfer of the gift by means of coercion or by fraud or by undue influence or by mistake, under such circumstances the gift may be revoked. The second condition is by agreement. By agreement, the gift may be revoked or suspended. If there is an agreement between the donor and donee to that effect, then the gift may be revoked or suspended if they made an agreement related to termination of the transfer of gift upon fulfillment of certain condition. Based on such agreement between the donor and donee, the gift may be revoked or suspended under section 126. Thanks for watching this video. For queries, feel free to contact subhanbande@gmail.com. For latest updates on various law topics, please subscribe to my YouTube channel.